Hello everyone, it is a great honor to be here to share some points to you guys. So, welcome to our FIELDWORK reflection video in the course EPPA2823 Business Law. So our topic is personal data protection and PDPA compliance in Malaysia. There's a highly relevant issue in today's digital world. So let me introduce my group members. We have Huang Ruonan and Zhang Xinzhe. So they consist of the following members. This video will present our research findings, legal analysis, and reflection on these important issues. So let's move to the first part, the background of the research. In recent years, the importance of the personal data protection has grown rapidly. So personal data includes names, and address, phone numbers, bank details, and even biometric or location data. So as more business move online, we're seeing increasing risks of data misuse and unauthorized access. And finally, in Malaysia, several indicators such as the global and KYC data leak have raised concerns about how well our data is protected. So the key question is, how does Malaysian law protect our data and how effective is it in the practice? So, and next we have to know what is the PDPA.
Hello everyone, today I want to introduction to you about PDPA. The main law governing personal data in Malaysia is the Personal Data Protection Act 2010, also known as PDPA. It applied to all commercial data used in Malaysia, excluding federal or state governments. Under PDPA, personal data is defined as any information that can identify a personal dignity and or integrity. There are 7 core principles under the PDPA. The number 1, general principles. Data must be processed with the consent of the individual. The number 2, notice and choice. Data subject must be informed of the purpose of data collection. The number 3, disclosure. Data must not be shared with proper authorization. The number 4, security. Reasonable steps must be taken to protect data. The number 5, retention. Data must not be kept longer than necessary. The number 6, data integrity. Data must be accurate and updated. The number 7, access. Individuals have the right to access and correct their data. The legal principles we have studied in this course can be directly applied to PDPA. From contract law, informed consent is required before processing personal data. The number 2, from tort law, unauthorized disclosure of personal data may amount to invasion of privacy. The number 3, from business law, companies are legally liable if they fail to protect data under the PDPA. The number 4, from customer protection, users have the right to control how their data is used. One notable case in the Grab data leak in 2022, where user information was exposed. Although the company take a step to fix the problem, it raised a question about internal data security practices. Other example is the alleged sale of Malaysia wager data online, which highlighted weakness in corporate data management. Their costs show that enforcement under PDPA is still relatively weak. Many businesses remain unaware of their obligation. Public awareness is also low, and few individuals exercise their right to data access of correction.
As part of our fieldwork, I conducted informal interviews with over 20 Malaysia internet users to understand public awareness and attitudes regarding personal data protection. The responses were eye-opening. A majority of respondents were unaware that their data had been collected or leaked. They had no idea what PDPA even meant. Some participants expressed a sense of resignation, saying things like, "My data has no value anyway," or "If they want it, just let them go." This shows a dangerous level of empathy and the normalization of data misuse. Interestingly, another group of respondents acknowledged that giving up some level of privacy feels like a necessary trade-off when using modern digital services. They accepted that signing privacy agreements, often without reading them, is almost like being forced to choose between access and protection. One interview said, "If I want to use this app, I have no choice but to click agree." This finding revealed a serious gap in digital literacy and legal awareness among Malaysia users. To address this, we believe that the Personal Data Protection Department should implement national-scale educational campaigns to increase public understanding of their legal rights. Additionally, tech companies should be required to present privacy terms in simpler, more visual formats to encourage informed consent. Embedding PDPA education into school and public sector onboarding could also promote long-term awareness. Through this project, I realized that personal data protection is not only a legal and business issue, but also a matter of social responsibility. People need to know they have the right to protect their identity in a digital age where surveillance is normalized.
So before we do some more researchers, we have to know what is the real situation in the world. That is an important element. That's the completion of the legislation in world's developed country. So around the world, many developed countries has taken strong steps to protect personal data through comprehensive legal frameworks. For example, the European Union has one of the most advanced law called GDPR, the General Data Protection Regulation, and it gives people very strong rights over their personal data and punishes companies that break the rules with a huge fines, up to 4% of their global revenue. That is amazing, right? And in the United States, although there's no single federal law, so states like California have introduced the CCPA, California Consumer Privacy Act. So it gives people the right to know what data is collected and deleted, and to stop it from the beginning. So, and also China passed the Personal Information Protection Law, PIPL, in 2021, which is clearly inspired by the Europe GDPR, and it focuses on the data maximization and strict on control over cross-border data. And there's another country, Singapore, has its own PDPA and Personal Data Protection Act, which emphasize users' consent and appointing data protection officers in companies. So compared to this, Malaysia was early to introduce a data protection law in 2010, but are falling behind it in terms of enforcement and public awareness and corporate compliance. Many people still don't know their rights, and data leaks continue to happen without serious consequences. So finally, if we want PDPA to truly affect, so we need to stronger enforcement, more education and better industry accountability, and just like what we are seeing in other countries.
In summary, personal data protection is not just a legal obligation under the PDPA. It reflects our right to digital dignity. While the law provides a framework, enforcement, public awareness, and corporate accountability are still lacking in Malaysia. As digital users, we must stay informed. As future professionals, we must ensure compliance.